So maybe you find yourself in a situation where you think that you can only be deported, that there's nothing else you can do in your case. Well, if that's your case or loved one is in that situation, this video is for you. My name is Jorge Molina. I am an immigration attorney based in Dallas, Fort Worth, serving clients worldwide. Today, we're going to be talking about why you would want to offer voluntary departure rather than taking a deportation order. And this applies mostly for people who don't have any relief, or perhaps they already tried to get something, but they weren't eligible for it, or there's some other issue. So today we're going to be talking about voluntary departure. First, let me explain the why. Why would you rather have voluntary departure over a deportation? Well, first off, if you get a voluntary departure, you avoid the deportation order, obviously. But here's the difference. If you have a deportation order in your record and you could potentially come back through a family member or some other way, some business petition or something else in a few years, if you have a deportation order, that's another ground for which you need to ask for forgiveness. If, on the other hand, you get a voluntary departure, and depending on your circumstances, you may avoid that that ground, that deportation ground, that punishment that they're giving you for having a deportation order. So, in essence, under the Immigration Act, Section 212A9, if your order removed, you're deported, you cannot come back for about 10 years. Now, you're eligible to waive that, but only if you show that you've been rehabilitated and show some other factors. So that is done through the I-212 waiver. Often you can get them, but the longer you've been outside the United States, the likelier it is that you're going to be able to get it. However, let's say you get a deportation order because you just didn't go to the proceedings. You skip immigration court. You figure, well, I have no form of relief. I have something very serious in my record, so I'm just not going to go. If you do that, that is not an offense that can be waived. Okay, so that means that under Section 212A6B, you cannot be allowed to come back to the United States for at least 5 years. It also, you have a deportation order, which means that you cannot come back for 10 years. And then the fact that you didn't show up to proceedings is a negative factor that goes against you when you're asking for a waiver. All right. So what do you do? What do you do if you're in that situation? You say, well, you don't have 10 years for cancellation or removal. Your children are too young to petition for you, or you have some other obstacle. Well, the best thing you can do is request voluntary departure. Now, there's two forms of voluntary departure. Okay, so the first one is preconclusion. So this one is requested at your initial hearing with the immigration judge. Here, this is the hearing. It's usually known as a master hearing. And in that hearing is where the immigration judge explains your rights to you, tells you you have a right to an attorney at no expense to the government, you have the right to present witnesses, etc. But if you don't want to move forward with or in immigration court, you can request a pre-conclusion voluntary departure. What you need to show is that you're not asking for any relief from the court, that you're telling the court that you admit that they can deport or remove you, that you're waiving appeal, so you're accepting the decision of the judge as final, and you've not been convicted of an aggravated felony, and you're not deportable for terroristic acts or reasons. So the benefit of voluntary departure is that they allow you to leave on your own terms. You have up to 120 days to leave the United States, and you can get your affairs in order. And then depending on how long you've been in the United States unlawfully, you may be able to come back within 3 years, after 3 years, or after 10 years. And in some cases, if you're married to a U.S. citizen or a lawful resident, or you're the spouse or the spouse of a lawful resident or a U.S. citizen, you may apply for a waiver after being granted voluntary departure. So you don't need to be outside the United States for that long. Now, that's pre-conclusion. Now, let's say you're debating, right? Maybe you have a weak case in court, but you want to try, you want to, try your best to stay in the country. You present the best case you can, and then you lose, right? Or you feel that you just don't have enough for that. Well, you can also ask for voluntary departure at the conclusion of proceedings. Usually, this is done when you're presenting testimony and you're making an offer of proof to a judge showing that you would be eligible for post-conclusion voluntary departure. So the first requirement for that is that you must have been present in the United States for at least 1 year. The second requirement is that you're a person of good moral character based on your record in the last 5 years. So what does good moral character mean? Well, we have another video for that, and we have a lot of content, but in essence, that you haven't been convicted of certain crimes, for example, crimes involving moral turpitude, anything that has to do with fraud or dishonesty or some other serious offenses listed in the Immigration Act. Also, you cannot have been convicted of an aggravated felony or anything related to terrorism, and you must show the ability and your intent to leave the United States. And that matter of intent usually comes up in cases that you refuse to produce a passport or show that you're willing to leave the United States. So, for example, if you're fighting an asylum case or a withholding case and you just absolutely refuse to go back to your home country, it's going to be somewhat difficult to show that you have the intent to leave the United States. But if granted a post-conclusion voluntary departure, you're allowed 60 days to leave the country. And which, is not as nice as 120 days, but, it's often enough time to rearrange your affairs and get everything ready for your departure. Now, what happens if you don't leave the United States after a grant of voluntary departure? Well, that grant becomes an order of removal, a deportation order. Then if you have a deportation order, you cannot receive certain benefits in the United States. So, for example, you wouldn't qualify for adjustment of status, cancellation or removal, and a series of other benefits. You also wouldn't be eligible for voluntary departure again. So my advice is that if you're granted voluntary departure, leave. And most importantly, if you're in immigration court or if you're called by an immigration judge, make sure you show up. That's usually half the fight, just showing up, and you have to. And if you don't, there's going to be very negative consequences. And on the plus side, you may be eligible for voluntary departure if you have no relief. If you have relief, you can fight your case. And if you're wanting to fight your case or seeking voluntary departure, you can always reach out to us. Again, my name is Jorge Molina. If you like the content of this video, hit like, share, and maybe write a comment. And if you'd like to give us a call, you can call us at 469-708-5800. Again, 469-708-5800. Or if you prefer to send us an email, you can do so at info@jmolina.law. Again, info@ the letter J, my last name, Molina.law. Thank you very much.